Hi, my name is Howard Kline. I'm a trademark attorney at Nath, Goldberg & Meyer. Today we're going to be talking about ways to defer costs when filing trademark applications with the U.S. Trademark Office. Many of our clients are entrepreneurs, and they come to us after filing trademark applications on their own and receiving office actions. While filing trademark applications on your own can certainly save costs in that you avoid the initial attorney service fee, there are many hidden costs in doing so. For example, many times what I see is applications that are filed with the use in commerce basis before the trademark was actually used in commerce. Likewise, applications filed in the name of the wrong entity, or applications filed for certain goods and services that are more narrow than they should be. And after you file a trademark application, you cannot expand the scope of the listed goods and services. So, for many of those issues, the application is essentially void upon filing, in that you cannot correct filing a trademark application in the wrong name in many cases. Secondly, if you file a trademark application for a narrow list of goods, you're stuck with it. And really with that, you may just need to refile an application altogether. So going forward, what I advise many of our entrepreneurial clients are as follows. One, filing a use in commerce application rather than an intent to use trademark application can save considerable costs. If you're close to commencing use, you can avoid filing statements of use extensions of time down the road that are involved with an intent to use application by simply waiting until you're using the mark in commerce and filing it. Those costs can be in the thousands of dollars throughout the prosecution of the application that you potentially save. Secondly, there's something called the Trademark ID Manual. If you filed an application that follows the list of goods and services from the ID Manual, the total cost per class can be reduced by $100, in that the ID Manual is $250 per class rather than $350 per class. And finally, the third option, and one that I really suggest to a lot of our clients, is if you're considering filing an application in 3 to 4 classes, let's say clothing in class 25, maybe you're selling a book in class 16, rendering business consulting services. What you're going to want to do or consider to do is you can file the initial application all in one class. So you can just pick and choose shirts in class 25, books in class 16, business consulting services in class 35, and file the whole application in class 35 together. And what that'll do is you'll pay an initial service fee, a government fee, of $350 rather than $1,050. Once you file that application, about 4 months later, the trademark office will review and examine that application. If it's approved, you'll get an office action basically saying, hey, in order to proceed, you'll need to provide a payment of $700 to cover the 2 extra classes. And at that point, you can choose whether you want to include all 3 classes or simply delete them out altogether and just proceed in one class for that $350. On the other hand, if you receive an office action refusing the mark entirely, you basically have a cost savings in play because you didn't have to file that government fee of $1,050. Rather, you spent the $350 up front, you found out it's not available, and you can simply allow the trademark application to go abandoned. If you have any questions about filing strategies, please feel free to reach out. We can be reached via email at ip@nathlaw.com or by phone at 703-548-6284.